Everyone, my name is Amirah Kumar bin Kamarudin. Number meeting 10DSE24F2010. Today I will explain about extraordinary general meeting or AGM. An extraordinary general meeting is a meeting held by a company to discuss urgent or special matter that cannot wait until the annual general meeting. This meeting allows shareholders to discuss and vote on important decisions that affect the company. For example, an EGM will be called to approve a merger, remove a director, or make major change in the company. Therefore, the EGM is important because it ensures that shareholders can participate in important company decisions.
Good morning, Mr. Parthiban. My name is Divya Darshini Sundar and my metric number is 01DAC24F2043. And today my group and myself going to present about Extraordinary General Meeting, which is EGM, and I would like to talk about the differences between Annual General Meeting AGM and also Extraordinary General Meeting EGM. So first of all, what is the main differences between AGM and EGM? AGM, in the word, in the name itself, it says annual. Annual means once a year. So annual general meeting is mandatory annual gathering, which means it is really important to have at least one meeting each year. Whereas extraordinary general meeting EGM call for specific or urgent matters. Extraordinary general meeting, it is not a compulsory for every year, but it is compulsory for the urgent meetings or the important matters to talk about. Frequencies, just like I said, AGM once every calendar year, which means every year, and extraordinary general meeting as and if when required, no limit, which means EGM there is no limit for the meeting callings. And I would also like to talk about the section. According to Section 310 Company Act 2016, members can request for the meeting. According to Section 311 Company Act 2016, director must conduct the meeting as members request. And according to Section 312 Company Act 2016, if the director failed to do the meeting, the members can do by themselves. So that is what the section gives us about the extra general meeting. For my next slide, I would like to talk about the scope of businesses between AGM and EGM. First, we talk about AGM. Reviewing audited financial statement, election or re-election of directors, appointment and fixing the remuneration of auditors, and also declaration of dividends. What it means? Overall, an AGM is a yearly review of how the company did on the past year. And we also talk about the ordinary businesses, which includes things like approving financial statements, reappointing auditors, and declaring the dividends. And we talk about EGM. Focuses on pivotal changes. Only the specific item listed in the notice can be discussed. And usually it involves special resolution which requires 75% of approval. So what it means? An EGM is used for special businesses or emergencies. And also at EGM we talk about special businesses like removing the director for misconduct or changing the company's name. We can do so. Finally, I would like to talk about the statutory requirements for public companies especially. First, we look for AGM. Notice period requires at least 21 days notice according to Section 340. What it means? It simply means for public company an AGM is mandatory every year under Section 340 and usually requires at least 21 days of notice. Whereas EGM usually requires 14 days notice for private company or 21 days if a special resolution is being passed. Just now we talked about special resolution which is 75%. And EGM is not mandatory. It only happens when it is needed. Whether it is an AGM or an EGM, the majority rule usually applies to both. And legal obligation. Annual general meeting mandatory for public companies. EGM never mandatory, it is purely reactive to the company's needs, which I explained just now. The AGM it is mandatory for the notice, but EGM it is not mandatory. It can happen whenever it is needed. Thank you.
My name is Kaludi Subramaniam. My metric number 01DAC24F2012. I would like to present about the reason for calling an extraordinary general meeting, also known as the EGM. Firstly, EGM is called where there are urgent business matters. For example, companies is facing financial difficulties, sudden problems, decision must be made quickly and cannot wait until the next AGM. Secondly, an EGM may be held for the appointment or removal of directors. This usually happens when there are issues such as poor management performance, misconduct, or when there are new leadership is needed to improve the company. Next, companies also call an EGM to approve the major corporate transactions. This includes mergers, acquisitions, or the sale of significant company assets. An EGM is necessary when the company wants to amend for constitution. This means changing the company's rules or regulations to suit current needs or new circumstances. Furthermore, an EGM can be used to make changes to share capital, such as issuing new shares or restricting company's capital. Lastly, an EGM can be called at the request shareholders. If shareholders hold a certain percentage of shares demand a meeting, the company is required to hold an EGM to address their concern. In conclusion, an EGM is very important because it allows company to make quick, effective, or a necessary decision to ensure smooth operation and protect shareholders' interests.
We explain the section related to the extraordinary general meeting, also known as EGM. Under the Companies Act 2012, Section 311 explains about the calling of meeting of members. This section allows a company to call a meeting of each shareholder whenever it is necessary to discuss important matters. An extraordinary general meeting is a meeting held by a company other than annual general meeting, which is usually conducted once a year. The main purpose of an EGM is to discuss urgent or special matters that cannot wait until the next annual general meeting. During an EGM, shareholders are given the opportunity to discuss, vote, and make decisions regarding important issues related to the company. These matters are usually required shareholder approve before the company can proceed with the decision. Therefore, the EGM plays an important role in ensuring transparency and protecting the right of shareholders. For example, Tesla may call an extraordinary general meeting to seek approval from each shareholder to issue additional shares. The purpose of using additional shares to raise more capital for the company. This capital can be used to support business expansion, such as increasing the production of electric vehicles, investing in new technology, or expanding into new markets.
Good morning, Mr. Parthiban. My name is Sandana Paramasevan. My metric number is 01DAC24F2037. Today, I will be explain about the case law related to extraordinary general meeting. Okay, the first case law is L of White Railway Co. versus Taharuddin. In this case, shareholder of L of White Railway Company, including Taharuddin, want to call a meeting to decide remove some of the director from the company. However, the directors refused because they believe the shareholder did not have any authorities to request the meeting. This issue brought to the court. So the court decided the shareholder have rights to request a meeting to discuss company affairs. This means that the director cannot stop shareholder from calling a meeting if they follow the proper instruction. This case shows that the shareholder as the owner of the company have a power to discuss important issue in the company. The second case is Baron versus Potter. In this case, two directors called Baron and Potter try to hold the board meeting and make a decision for the company. However, the company required minimum number of directors known as quorum to be present in order for the meeting to be valid. Since only Baron and Potter attend the meeting, so the required quorum is not met. So the court ruled that the meeting is not valid. Also, the decision that made or the decision that the Baron and Potter discuss is also not valid. In the conclusion, EGM is a special meeting for urgent company matters and the shareholder have rights to call it when it's necessary. Case law like L of White Railway Co. versus Taharuddin and Baron versus Potter show that the meeting follow proper instruction, including have a proper quorum to be valid. Thank you so much.